Hello everybody and welcome to this week's edition of Lawdit, Solicitors Tear It Down podcast. And this week we're going to be tearing down all matters relating to prenuptial agreements. Prenups, you've probably seen some Hollywood shows about prenup agreements. Are they valid? Are they legal? Are they enforceable? So I'm a little bit in the dark on this subject because it's not my area. So we've dragged in two of our specialist team of solicitors. Esteemed Mr. Reed and Mr. Killivan, who both are significantly experienced in this area. Good afternoon, gentlemen.
Good afternoon, Michael.
Hi, Sam.
Hello, Michael.
So I'm, like I say, I'm
just going to take over this point here because I asked Michael to do this podcast and for him to be definitely present for it. And the reason why is because we had a discussion several weeks ago and it just got on to prenuptial agreements, and you openly admitted, you said, you know what, I genuinely don't have enough information in my bank, in my brain to hold a conversation about it. So I said, well, let's do a podcast.
Well, I always think a prenup something to do with along the lines of myself and yourself get married.
Ooh, okay.
And I win the lottery and we then divorce and you want to get your hands on my lottery. So I'm not saying we've actually formally got married. We're living together.
Yeah. And
I win the lottery, and then we split up. And we had an agreement beforehand that anything like that happens, you're not getting your sweaty mitts on my money.
Well, I think you've led us neatly onto a general preliminary understanding that Sam's going to take over. You've got two types, and you've got a prenuptial agreement and you've got a postnuptial agreement. Now, we're not going to be really discussing postnuptial agreements today, so just go for it. What is a prenuptial agreement?
So a prenuptial agreement is a agreement that often people they're considering getting married, but they want to almost preempt if the worst was to happen and their marriage was to fail. Is there something we can put in place so that we can agree now how we're going to divide the finances? Hopefully it won't happen, but if it does, how we're going to divide them, rather than it all being up in the air, so to speak. Mm-hmm. And they'll come together and they'll draft an agreement, a prenuptial agreement, and that will sit there, and then they get married. Several years may pass, 10 years, 15 years, whatever, and they doesn't work out, marriage fails, they get divorced, and now they're into how are we going to divide the finances? Well, We've got this prenuptial agreement.
Okay, so if you've got the agreement and that's already been done, dusted, signed, I mean, we'll go through the process of that in a moment, but if that's happened, then why would there be a discussion about it? Why could it become contentious if you've already agreed on everything? Then everyone knows where they stand, surely.
Well, it's because prenuptial agreements are not automatically legally binding. You cannot agree to exclude the family court's jurisdiction on deciding the financial divide and financial remedy, really. So because of that, you have to go all the way back to 2010, and there's a big Supreme Court case all about prenuptial agreements where the court has given essentially their view on how they would treat prenuptial agreements. Mm-hmm. And there's certain factors.
But why was it 2010 when that happens? Why 2010? What was the position before then?
And the position before that was the court just wasn't really interested in them at all.
Oh, I see.
They wouldn't really be taken into account.
So then what happened in 2010?
So in 2010, from the court, now they say a prenuptial agreement, the court will certainly consider it, and as to how much weight it carries when the court comes to decide in the financial remedy, which may just be along the lines of what the prenuptial agreement says, or it could be something else. What they will look at is various factors around the time when it was made. Was it voluntarily entered into by both parties without any duress or pressure? Did both parties take independent legal advice when they were entering into this agreement? Did both parties give full financial disclosure at the time, so they had the full picture of what it was they were agreeing to? They look at the timing, when it was made in relation to when they got married. And when they consider all of this and they look at the terms of the prenuptial agreement, what they're really looking for is whether, if everything, all of this is in place, is whether the terms are still fair and reasonable to carry out and some things can happen along the way which would affect whether they would deem fair or reasonable. The biggest one ordinarily is a couple write a prenuptial agreement, they don't yet have children, they don't even consider the possibility of children, they get married, they have 1, 2, 3 children, and then when they come to get divorced they have this prenuptial agreement in place, but you've got the child, which is, well, the children of the married, which under Matrimonial Causes Act is the sort of first consideration when parties are divorcing the needs of any children of the married or civil partnership.
So therefore it won't be a simple case of, but we'll only recognise anything post prenuptial agreement when thinking about the children. You're saying that they could override the prenuptial agreement if there is a need to.
The court is not, they're not bound at all. They look at a prenuptial agreement, they look at all the guidance from the Supreme Court case, and they attach weight to it, depending on how it was entered into, depending on what's changed in the marriage since then.
Well, use that
financial
example,
circumstances,
though.
children.
If you say children, and the financial circumstances, if you say, let's just make up the figures, right? So you've got prenuptial agreement where you know that the assets that are contained within that prenuptial agreement add up to around about, say, 20 million.
Yeah.
Okay. Thereafter, you have children. Okay, and the available pot after the prenuptial agreement has been signed has fluctuated. It's gone up and down. They've been together for, say, 10 years or whatever's gone on. But they've ultimately got to a point where they're divorcing, where when looking at that marital pot, so that's nothing to do with the prenuptial agreement, it's circa £200,000, right, that's available in there. That's an example of where the courts, I presume, would go, that's not sufficient for, the parties to have the children housed, but there's one, let's say the husband or the wife, is the one that's got the 20 mil sat in the bank that's not going to be touched. Can they override it on that regard, simply because we've got children now, and they need to be housed? There's a needs argument there, so therefore we're going to cut a line through that that shield, so that we can access the funds that are contained within the prenuptial agreement.
Yeah, absolutely. They can effectively tear up the prenuptial agreement, ignore it, and make whatever order they see fit. But in terms of the prenuptial agreement, you've got the assets that have almost been like ring-fenced at the time of the agreement, and then as you've got the course of the relationship and the marriage, you're going to have other assets potentially that have come along the way that aren't then ring-fenced, as you spoke about. So, but there's a possibility that maybe there's enough assets outside of the prenuptial agreement that can fulfil needs of the party and children.
I guess, isn't there some, if I was acting for the wealthy person who wanted to protect his or her assets, I would insist on the recipient, my partner, going to see a solicitor, paying for the solicitor's advice, and really drumming down exactly what
that's what we were saying earlier. That's a legal requirement, that you have to get independent legal advice, and both parties need to satisfy that before it is signed.
But really drumming down the importance of what they're agreeing to, so it's very difficult for them to argue later on, I wasn't aware, because so many people do that. I wasn't aware argument. I don't think in these days we don't tend to find people say, well, I didn't know what I was signing, because they really do get it drummed down to them when they go and seek that ILA. It's usually reasons why. Even where the children, even where you say you haven't got children now, but if you have children, this is still legally binding. You are fully aware of that, aren't you?
But so we're arguing that it's not always legally binding when you have children. It's the opposite.
But you're saying you're not going to sign this prenup until you get that confirmation. That person knows that even if I have children, this is still binding on me, because it's been repeatedly expressed to me in this agreement that this is legally binding. Or don't sign it. Because if you're signing it in the full knowledge that you've been told repeatedly by your own legal team that this is binding, then how can you turn around and say, I'm sorry about that, I didn't know.
Just to be clear, but it's not necessarily binding. It's not something that can be bound by. So that no lawyer is going to tell someone when they have that ILA, you do realise that even if you have children, this is legally binding, because actually the argument is it's not. It's something that can be ripped up and thrown away, so that all of the assets can be.
And that's based on the
looked
fact that such is the significance of what that person is agreeing, it can always be overturned based on the unfairness of it, on the circumstance. So it's not like the employment situation whereby you have a compromise agreement and you have an independent solicitor looking at the agreement and signing it and waiving all their rights. But that's very difficult to overturn.
Because, okay, so you break the argument down into twofold. Someone goes and has independent legal advice, ILA, on what they're signing, okay, and none of the circumstances change thereafter, but they marry, and then suddenly they try to argue, like you say, oh, hang on, that's not fair, no, I want to be able to access it. The reason why you're getting independent legal advice is because you're told you need to go and check to see exactly what's going on and what the legal rights are and, you know, obligations are upon signing. That's one fold. That means nothing's changed at all. So therefore, that point that you've raised there is absolutely valid. Well, you've gone and sought independent legal advice. You knew that you were signing it, so see you later. The other half of it is, but what about when circumstances do change? And even when the independent legal advisor says to you, well, if just so you know, if circumstances change, then these are the reasons why actually this prenup may or may not be able to be relied upon. Well, that will get said to both parties, and there are circumstances which Sam was just going into where they can actually rip it up, and children is one of them. There's a needs argument.
And I suppose that makes perfect sense. So if, for example, child coming home from school one day in a terrible car accident suffers brain damage and needs 24-hour care, that prenup will be ripped up because circumstances have changed.
Very good point. Very good point. Yeah. Sad point, but very good point.
It's important when you get the prenuptial agreement that you consider if you are going to have children, because if you are, then you should put things within the agreement to try to factor in that outcome. That would give it a little bit more support. But it often depends on what assets are outside of the agreement and whether all the parties' needs can be met. In a situation where you've got sort of two wealthy individuals and they both want to just keep their finances separated, then you might find you're in a situation where everybody's needs can be met and the prenuptial agreement can be upheld with everybody's needs being met because you've got two wealthy parties. But I think it's more when you've got a very one-sided situation where you've got one wealthy party who's insisted on a prenuptial agreement to protect their assets and then a weaker party.
Okay,
so just not very romantic though, is it?
Well, no.
Do you find in the years you've been doing this that it's a common thing? It's more common now than it was back in the day.
Yes,
very.
Yes, we have a lot more people that are asking us to draft prenuptial agreements. Yes, and postnuptial agreements, but that's not for the purposes of this podcast.
It's not very romantic, though, is it?
No, I know what you mean. But look, at the end of the day,
you're contemplating the end, aren't you?
Yeah, by saying it. Yeah, it's like the chicken and the egg argument, isn't it? Should you, shouldn't you? So just want to be clear, just to end this first point, Sam, just so that for our listeners they know where to turn to. Just tell me, with the 2010 case, what is the name of that case in the Supreme Court, so that our listeners can go away and have a read of the judgment?
Radmacher and Granatino, 2010.
2010. Okay, so we'll probably make sure that there'll be an article done on this, and that will probably feature within that.
If I remember rightly, that only it was Lady Hale at the time was in the Supreme Court, and I believe she was the only judge that went against the judgment, and all the other judges were for it. It wasn't it was a majority rather than all in agreement.
There's a very good podcast with Lady Hale with The Rest Is Politics with Alistair Campbell and Rory Stewart. Gary Lineker's his big goal hanger podcast company, and very interesting. I thoroughly recommend it, and she's delightful.
Right, okay, Sam, so we've already gone through what the legal status is and how the courts treat prenups. When you've just gone on about the factors, just explain to us again, just in bullet point form, what the obvious factors are that the courts will consider if someone challenged a prenuptial agreement.
So going back to, they look at the time when the agreement was made, were both parties entering into it voluntarily without any pressure or duress or last minute demands, not marrying you next week unless you sign this. And they also make sure that both parties at the time gave full financial disclosure, so that they both know what it is they're agreeing to, the full picture of the assets, Both parties took independent legal advice and were therefore advised on what it was they were entering. Ideally that it was signed and agreed in advance, in advance of the wedding, a month plus. It gets a little bit more, the closer it is to the wedding, the less ideal the timing is, because then you get the question of pressure and last minute demands. And then if all of that is in order and as it should be, then it's more of a case of then looking at the terms and the circumstances today at the point of divorce to see whether it would still be fair and reasonable to uphold the terms.
Right. Okay, that's very useful. So, moving forward, I just want to be just clear for our listeners. The overriding duty, you mentioned about the welfare of the children. Just explain to us a little bit more about, the most obvious factor that the courts will have to consider. And you mentioned about needs, so I just want to know for our listeners, it's just not just about prenuptial agreements, this is just about financial remedy, and a big point to consider. I know we touched on it in the previous podcast, but just explain to us again, for the purposes of the listeners and Michael, regarding a needs argument when it comes to financial remedy.
So a needs argument, so you have, and so Section 25 of the Matrimonial Causes Act sets out in A to G all the considerations the court will think about when they're deciding upon assets and the division. And first and foremost is the welfare of any minor children of the family, children under 18, and then the needs and obligations of each party. So needs can be a situation of what does one party need. So if you've got a more, some would say, traditional marriage now, where you've got one party who works and brings all the income in, and another party who has been a stay-at-home parent and has not worked for 10 years because they've raised the children and maintained the house, cooking, cleaning, running errands, all those important things that are equal contribution to the marriage as far as the court is concerned, then you're going to look at that party, and that party who's been the primary care of the children presumably is going to continue being the primary care of the children. So they have a greater need for housing that accommodates the children because of the children's housing needs. Also have an income need, bearing in mind they've not potentially worked for 10 plus years because they've been the stay-at-home parent. And those needs will, in a way, it will trump other considerations, and the court will look to fulfil those needs as best they can.
That's right.
Within
and of course, it can be not just about the children. That's just the usual point on a needs argument. It could be that you've got a wealthy individual marries someone that's not wealthy. So putting aside prenuptial agreements completely for a moment, they then married for several years. They've been accustomed to this wonderful standard of living, this lifestyle, private jets, going and sunning themselves all around the world, and of course, an income that comes from the other party, giving them an allowance, so to speak. And then suddenly they get divorced. They're used to a standard of living that's so high that they then can command, by way of a needs argument, that I need, but even though the word need sounds like, well, you don't need that, but it's just the legal point. As a needs argument is then, I need this, I need that, I need the other.
Needs is subjective in the sense of the standard of living of the marriage is another consideration of the court, and in the situation you just described, then the needs then can be subjectively a lot higher, because it's if there is the pot available, because you're talking about a matrimonial pot of many millions, then needs can be keeping that party into the lifestyle they've been accustomed to as much as possible.
And then, of course, that then bringing back into the fold the prenuptial agreements, again, that would trump everything in any event. If their need is greater than what's available in the pot, then they start to look at what's beyond and arguably protected by the prenuptial agreement. Useful. Okay, that is very, very useful. Michael, have you followed all of that?
I have, and I'm still a little bit sad that it's so unromantic.
Oh, you big romantic, you.
But I get it, and I think it's sensible and wise
In circumstances,
advice
yeah,
to follow it in
absolutely.
the circumstances. But don't forget the romance, chaps.
And a nice way to end it. Michael, thank you very much. Sam, thank you for that. That was very useful. I'm grateful. Closing comments, Michael?
No, so thank you everybody, and I hope that was useful, and we'll talk again next week with another Tear It Down podcast. So thank you everybody.
Thank you very much. Take care. Bye.
Fire of the